welcome everybody to our panel on understanding your insurance policy and pitfalls. And I think it'll be an interesting group. We've got some outstanding speakers and people with a lot of knowledge to bring to bear on these issues. To my immediate left is Mr. Baxter Southern. He's president of McGriff, Missouri. He has more than 20 years of brokerage experience. He is focused on the development and implementation of specialized insurance placements for clients in a number of industries, including construction, marine, manufacturing, hospitality, and real estate. Baxter has lectured on topics including the Jones Act, longshore, directors and officers liability, general market characteristics. He's also published in various periodicals on a variety of risk management related topics. So please welcome Mr. Baxter Southern. A little further down the panel, third from my end here is Mr. Elliot Benoit Jr. He's a licensed attorney, insurance broker, and commercial lines coverage specialist. Elliot practiced law for a period of time with a focus on complex commercial and IT litigation before moving into the insurance space. He is currently a partner and shareholder and commercial insurance broker at the Crane Agency. He's licensed in all lines of commercial insurance coverage in all 50 states with designations in management liability and cyber lines. So again, please welcome Elliot. You don't need to applaud for these next two guys. Ted Lucas and Ryan Moore are my fellow partners at Fox Smith. Ted has more than 30 years of litigation and transaction experience, although he doesn't look it, with an emphasis on maritime, OSHA, Coast Guard, marine construction, and commercial litigation, often involving coverage issues. He's tried numerous cases to verdict in a variety of jurisdictions. He's successfully defended high exposure complex cases in federal and state courts throughout the Midwest. He's represented marine transportation companies on cargo and property damage claims and has obtained recoveries on behalf of marine insurers seeking subrogation on large property damage claims. Ryan Moore is a partner at Fox Smith as well. He's down at the end. He focuses on commercial and environmental law as well as privacy and data security issues. He's actually an environmental engineer as well, before a profession he was involved in before becoming an attorney. Handled a variety of corporate compliance issues, primarily focused on land and water concerns, as well as waste management minimization. He advises senior corporate attorneys and executives regarding a variety of compliance and litigation issues arising from state and federal environmental regulations and enforcement actions. He's representing companies in a number of areas. So today we're going to touch on 5 areas, but probably focus more on a handful of commercial general liability, cyber, and employment policy will be our primary focuses today. Baxter, the crowd here probably knows what a CGL or commercial general liability policy is. Could you break down for us in general what are the key components?
Sure, I'd be happy to. First of all, I just wanted to say thank you for the opportunity to be here, present, and talk through these topics. Really very much appreciated from me. But big picture, the commercial general liability policy, or the CGL, this is the most basic liability protection that you have in place for your business, and it's designed to protect you against third-party bodily injury or property damage. You'll hear me refer to BI and PD, or bodily injury and property damage, a number of times throughout. But the covers that are typically afforded in the CGL policy, coverage A is the bodily injury and property damage. Coverage B is personal and advertising injury. What is that, you might ask? That includes things such as false arrest, malicious prosecution, wrongful eviction, slander, libel, oral or written publications, or infringing on somebody else's copyright. Coverage C is medical payment. This is a sort of a no-fault, here's $5,000 or $10,000 to take care of your problem, so you'll just go away cover. And then finally, products and completed operations, which is coverage for bodily injury or property damage that is caused by your product or by your service.
You mentioned bodily injury and property damage. Expand on that a little bit, if you would.
Right, so the whole point of the CGL policy, at least in my opinion, or what we use it for the most often, is this third-party bodily injury or property damage. And what the coverage says is that we will pay those sums that the insured becomes legally obligated to pay as damage because of bodily injury or property damage to which it applies. We have the right and duty to defend, which is very good news for our lawyers in the room because that means somebody else is paying their bill as well.
Neglected to say right at the outset, we're going to try to cover a lot of ground here, which is old news. Everybody's been doing that today. But if you have questions, raise your hand and we'll get to them because we have some really good people here that can help you with answering those questions. CGL exclusions. Our next couple of slides touch on that. Why are those important?
Well, the CGL policy is what would be considered an all-risk policy, meaning that it's covered unless it's excluded. So yeah, there's a whole lot of exclusions. Matter of fact, by my count, roughly 39 exclusions in the standard CGL policy form. We've listed some of them here. I'm not going to hit on every single one of them, but the point of the exclusions are because the coverage is so broad, they're needed to narrow the scope. A couple of here, you'll notice that it says that they are covered elsewhere, things like workers' compensation, auto, and so they're excluded here so as to not duplicate coverage. The last one here, property damage to property that you own or that is in your care, custody, or control. This is a very major exclusion that comes into play a lot of times that people don't think about. If for some reason you have a hold of something, if you've got it in your hands and it is damaged, then it's likely not covered by the CGL policy. So the other part, if you wouldn't mind just flipping through to the next one.
Yeah, I wanted to ask you about one on this one,
Sure.
on the first page. Expected or intended injury, if you meant to do it, that's on you. How does that even arise?
Well, have you ever wanted to knock the crap out of somebody?
No comment.
If you do, and you do it on purpose, then it's potentially going to be excluded. If you know that what you are going to do is going to inflict bodily injury or property damage, and you did it anyway, then it's going to be excluded. It's meant to be accidental.
And then the war exclusion. I do a fair amount of coverage work, and I see that in virtually every CGL policy. Why is it still there, and should it still be there?
It's still there because there is coverage that can be bought outside of the CGL realm. It's insurance at its best can be anachronistic, and if an endorsement or an exclusion was good 20, 30, 40, or 100 years ago, it's still good today. We still handle policies that have year 2000 exclusions on them 21 years later.
One of the aspects of CGL was coverage in the instance of an insured contract. How does that arise?
Right, so you'll notice, or we talked earlier about the fact that there's an exclusion for contractual liability, which is assumed liability, unless it's assumed in an insured contract. And this really gets to the heart of indemnification and accepting somebody else's risk. This is an example of where you buy back an exclusion or you exclude an exclusion in order to have coverage. Excuse me. And so what the policy does is it defines an insured contract, and this is just one part of that definition. And obviously, I've even cheated and shortened it up even more, but it's the part of the contract under which you assume the tort liability of another party. When your business takes out a CGL policy, it takes out that policy in the name of that business. However, you are often going to be required to sign contracts or agreements where you indemnify a third party and you agree to indemnify and defend a third party. Well, the cover wouldn't respond without this carve out.
Got a couple of examples of how exclusions can apply.
Sure. So some of the ones, and I think the slide got jumped a little bit, which is fine, but one of the care, custody, and control, which we mentioned briefly. So you're a contractor, you're building a new building for a customer. During the course of construction, the partially built structure is damaged due to your negligence, right? You swing a crane into it as you're setting the final piece of the process. Well, care, custody, and control exclusion in the CGL policy excludes this cover from that area. And that's the reason why we have what's called a builder's risk policy, which is for property in the course of construction. So there's an entire cottage industry of insurance policies that have been designed principally around the care, custody, and control exclusion. The second one that we'll talk about just real quick is you sell a widget, and that widget explodes after it's delivered to the customer. This is so the widget itself is excluded because your product is excluded. Again, your product is your product. It's not a third party. What is covered, and this is the completed operations or products completed operations covered, we mentioned at the very beginning, is the third party bodily injury or property damage, a lot of times what we would call ensuing damage. So if you figure a widget's $5 or a microwave, that's not a big deal. But if your widget is a multi-million-dollar piece of equipment, that's going to be a pretty substantial issue.
Naming and waiving. Ted is going to talk a little bit about this. In the first instance, what is it and why is it important?
First, thanks to everybody for coming today, both remotely and in person. It's always good to see everybody again. So thank you to Baxter for his comments. We all have the benefit of, I don't know, 30 to 50 years of insurance brokerage experience, so take advantage of it.
More than we wanted.
Right. So anyway, with regard to naming and waiving, everything we're talking about today relates one way or another to managing your risk. And naming and waiving is just a part of that program. It's a very effective, potentially, and inexpensive way to manage your risk. So what is naming? Simply naming a party as an additional assured on a liability policy in most instances. Waiving, what are we talking about there? We're talking about waiving subrogation, which means that an insurance company cannot go after a person to recover an amount it has paid off in connection with whatever the activity is covered by the contract between the two parties, one identifying the other. So that's waiver of subrogation, naming and waiving. So let me just give you a common example. As you can tell from the introductory comments, a lot of my work is in the marine field. So this example is from the marine field, but this practice happens in many industries, and you should all take advantage of it to the extent that you can. So let's say you own a terminal here in St. Louis City or across the river in Illinois on the Mississippi River where barges are loaded with grain. And there's a lot of that going on around here. Anybody that drives across the bridges has seen clouds of dust coming up, material being loaded in barges. Well, that terminal owner has to hire a company called a harbor service that owns towboats to deliver barges to its dock. They're empty, then they're loaded, and that same company needs to pick them up and take them away. Now, the guys that work on the towboats for the harbor service have to get on your dock and loosen lines, tie lines, do other things depending on what kind of a dock it is. As the owner of the dock, you're paying the harbor service for this service they're providing you, and you just assume not assume any risk for their people. You don't want them getting hurt on your dock or next to the dock while they're doing something involving the dock and suing you. So in your contract with them, you have to make them agree to indemnify, defend, hold you harmless, name you as an additional assured on their liability policy, and waive subrogation against you. So that's an example of how this works, or when it can be applied. But again, not limited to the marine business. I mean, I would think that if you own commercial property, you're a landlord, you're leasing, office space to companies, you don't want to be on the hook for your tenant's employees, or their customers that are in the space. You want to shift that risk to the tenant. And there are many other examples where you can use this tool.
You have a lot of companies, say in the construction business or in the maritime business, have pre-formed contracts in which it's already stated what they require on indemnity, being named insured, waiving subrogation. Can those things be negotiated?
Yeah, absolutely. I mean, there are certain constraints, just practical constraints dealing with, leveraged position in the industry. If you're dealing with a major barge line and, you're a small gravel loading facility, your ability to negotiate is limited. But yeah, I mean, theoretically, these things are all negotiable. And I would point out one thing, obviously in any contractual arrangement between two businesses, the scope of work and the payment, how much somebody's getting paid for, those are the key terms. And when the business people making the deal figure that out, a lot of the rest is just the details, And what I noticed is that these insurance provisions in the contract and the naming and the waiving and the indemnity are sometimes can be overlooked, particularly by less sophisticated companies in the rush to get a deal done with the major terms already having been agreed to by the principals. But really the reason I wanted to talk about this today is because I've seen it go wrong a number of times. As I said, it's a very effective and inexpensive way to manage the risk, but it has to be done properly. And I've seen cases where general contractor A hires subcontractor B. Subcontractor B says, I'll indemnify you and defend you for any injuries by my people, my employees, if they sue you, general contractor. And all sounds great. Then the accident happens, Let's say building a bridge across the Mississippi River. General contractor hires this subcontractor iron working company. And they're tying rebar and making forms together on a barge. So these guys show up every day, iron workers for the subcontractor, and they're working on this barge on the water. And iron worker climbs up a ladder on a scaffold to build this big steel structure on the barge, gets to the top, foot slips on a rung of the ladder that may or may not have been defective. Back, the iron worker goes, falls 15 feet to the deck of the barge, boom, multiple fractured vertebrae, shattered leg. And this is somebody making, $90,000, $100,000 a year. That's a big claim. And so the general contractor says, well, whew, so glad we had them name us as an additional assured and agree to indemnify and defend us. The only problem is the only policy on which the general contractor was named as an additional assured was a comprehensive general liability policy, which excludes, and Baxter touched on this, Jones Act claims, which this would be, and it also excludes as a watercraft exclusion. It doesn't cover things that happen on certain types of vessels that are owned or operated by an insured. So all of a sudden, general contractor turns the claim over to the subcontractor's insurance company. Hey, this is on you, not so fast. Exclusions doesn't apply, you are on your own. So my point in that story is you got to, while this is very effective, it's not expensive to do, you have to be careful when you do it to dot your I's and cross your T's.
I'm representing an insured currently as a claim under a policy that was purchased for the express things that went wrong, but the exclusions seem to rule out coverage. And query what they were insuring or what did they think they were buying when they signed off on it. There was a lack of thoroughness up front.
Hey, Mark.
Yes, sir.
So Baxter, you're my broker, and I've got a contract where I'm named Wade. Obviously, I should be concerned about whether or not, in fact, I'm named on a policy that's going to protect me for the enterprise that I'm engaged with this other party. What, as my broker, would you do for me to make sure that in fact I'm in a circumstance where I'm covered?
Well, I think the main thing where you're receiving the protection, that doesn't eliminate the coverage that we buy for you.
Right.
And I often try to differentiate with our clients the difference between, there are multiple ways to do risk transfer. One of them is buying insurance coverage, but the other one is to shove that risk onto somebody else. They don't operate, it's not one or the other, you do both. And so, a lot of it is that you layer protection that's there for you just in case, obviously with the idea that we're trying to get as much protection from out other sources and stay off our losses trade.
Right. Oftentimes, these contracts will say that annually I have to be provided with a certificate of insurance that says that I'm named on this policy or whatever. If I get that certificate, assuming that I'm so diligent that I actually check every year to make sure I'm getting it, because sometimes our clients forget to do that, but let's assume we get it. If I'm, again, your customer, your client, and you're my broker, can I send that to you and say, does it look like they've gotten me what I need?
Absolutely. And we will tell you that the amount of time it takes you to blink is about how good that certificate's good for. But it's what we have. I can't tell you that every provision of the contract is covered by insurance. But I can at least tell you, all right, they've got, they appear to have the outlines in place because it'll tell you, who the insurer is, it will give you the limits, it will give you the policy numbers, and will often include language that reflects some of the terms and conditions. And I know that Ted had a number of comments on this, including the fact that it states on there it's issued as a matter of information only.
Right.
If I can just add to that real quick, the certificate only shows, as of the date the cert is issued, what policies in general the insurer has. What you can do if you want that added layer of protection is you can actually request to see a copy of the endorsement that names you as the additional insured. In some cases, policies have blanket additional insured endorsements. You could ask for a copy of that, and that'll show you as well. And one thing that you want to also do, and it's sometimes required by the contract, is if you can get it, you want the certificate to show that the cert holder is not primary. So you would ask for primary non-contributory language to be reflected on that certificate, which means that whoever's giving you the certificate is saying that their policy will respond first. Because in many cases, as Baxter mentioned, you already have the coverage, but you don't want your coverage responding first. Yours would be excess.
Kind of underlying all of this, but if the client ends up calling the attorneys and says, well, I think I've got coverage, but what do you think? My first comment is send me the policy and let me read it. Because you can't go by a certificate. You can't go by what's been represented to you. You actually have to see the policy.
And just as a sort of a final comment on that, though, I will say, imperfect as they may be, outside of sending a whole, insurance policy, which a lot of our insurers going the other way don't want to do, because it obviously has proprietary and what they would consider business confidential information. But a certificate of insurance, and specifically an Accord certificate of insurance in most states, is really the only tool that is available to us. For years and years and years, when I first started in the industry, up until about 10 years ago, at least for the marine side, we would send out cover notes, had tons more information, was far more descriptive, and the states just kept passing laws that said you can use Accord or nothing. So, I mean, it's a bit of a trick bag. To Elliot's point, getting copies of some of having them include some of those endorsements is a good way to help manage that.
I want to move us toward indemnity because we have a lot to cover. Ted mentioned that a moment ago. What's the importance here?
I'll get to that in a second, but what this whole conversation just illustrated, and one of the main points I wanted to leave everybody with today is the importance of having the contract and the policy reviewed by your broker and your lawyer to make sure it's right, and that the language in the contract is consistent with the policy in question and vice versa. It's absolutely key, and best not to wait until an hour before you're about to sign the contract. You know, give everybody a little bit of time, because if you've tried to read these provisions, I mean, reading the indemnity section of one of these contracts will make you cross-eyed. Reading the insurance section will make you dizzy. So it's not something that can be rushed. You got to leave a little time in the contracting process for that review to happen. With regard to Bart's indemnity question, I mean, all of this is part of the deal, you know, the indemnity and the insurance. You know, an indemnity provision without insurance, in my view, unless the contract, the other side of the party, you know, Apple or, you know, IBM or a really big company, you know, could pay a bill. An indemnity provision without insurance is not worth it. Paper is written on. I mean, you need to be backed up by insurance. But there are instances where you can't be named as an additional insurer always on certain types of policies. Like, you know, for instance, on a workers' compensation policy, let's say, you know, my dock example, right? And Fort Compton applied guys that work on the boats, but let's pretend for a second it does. And you say, hey, I want you to indemnify me, you know, or make me an additional insurer on your workers' comp policy in case, you know, one of these guys, you know, comes after me. Well, the workers' comp policy only covers the employer, and you're not the employer or the guy working on the towboat, so you can't be named as an additional insurer on the workers' comp policy. Now, the workaround for that is, number one, you still get the indemnity provision for whatever it's worth, but you get a waiver of subrogation, which at least prevents the other party's work comp carrier from coming after you after having paid out a work comp claim for the other guy's employer. Now, there are some restrictions on that in Missouri and probably other states as well, but in Missouri, you're limited in waiving subrogation in the construction context. But
Illinois too, I think.
well,
It's different.
yeah, there's, you may be referring to, you know, I'm jumping ahead here, but in anti-indemnity statutes come into play. Missouri has an anti-indemnity statute. Most states do. Illinois does. Illinois says, just prohibits, you know, in the construction field. You cannot be indemnified for your own negligence, period, end of story. Missouri is a little different. They give you a little latitude. It basically says you can, general contractor, you can't be indemnified for your own negligence. You can't force the subcontractor to indemnify you for that unless you give them an opportunity to buy insurance and pass that cost on to you, and then their liability obligation is limited to the amount of their insurance. So that's some limitations on the indemnity area, but again, that's construction related limitations.
And just as kind of a more general statement on this same topic, and is that to Ted's point, the insurance provisions are simply providing the financial backing for the indemnity obligation. The indemnity obligation will always exceed the scope of available insurance coverage because indemnity provisions are written without exclusion or with only very, very limited carve-outs. And it's impossible for insurance to apply to everything. I would tell you that it's going to apply to 99% of the situations. But as a broker doing these contract reviews, we always have to tell you that you're taking uninsured risk.
And part of the takeaway here, and you heard it from both Ted and Baxter, is talk to your brokers, talk to your attorneys. I've had insureds call me without having talked to their brokers. I haven't seen the policy, I haven't seen a certificate, but they haven't even talked to their broker about what the issues are in a particular coverage. I always recommend that they do that. Talk to them first, see the lay of the land, and then, you know, if you need us, we're here. Come back and see us. A couple more CGL issues, and then we're going to move on to some other things. Coverage for emerging internet and cyber. We're going to speak about that. Elliot and Ryan will talk to that in a few moments. Data and analytics. 20 years post 9/11, there was a lot of 9/11 coverage recently because we're 20 years out. Do we still need terrorism coverage? Thoughts, questions?
So the term terrorism coverage, I think, is one that's a little misunderstood. Traditionally, what that is referring to is what's called TRIA, or the Terrorism Risk and Insurance Act, which was passed in 2003. TRIA created a federally funded reinsurance program as a result of carriers excluding terrorism in the wake of the 9/11 attacks. Within the provisions, it defines terrorism as an act certified by the Secretary of the Treasury in consultation with Homeland Security and the Attorney General to be a violent act or act dangerous to human life, property, or infrastructure that have resulted in damage to the U.S. that have been committed on it. Anyway, it's a very prescribed piece of cover, all designed around this federal backstop. So from the perspective of do we still need it? Yes, we do, because otherwise carriers are going to exclude it. Right. The problem is that the TRIA coverage is just a part of the puzzle. And since the act went into place, I'm not aware of any event in the intervening 21 years that is qualified under TRIA as a terrorism incident.
But when you need it, you need it.
Right.
There are policies that offer terrorism coverage where you wouldn't need it. So, for example, if you have a separate earthquake policy, by law they're obligated to offer terrorism coverage. But looking at just about every scenario we can try to look at, we've never come up with a way that a terrorist act caused a true natural earthquake. So you might not want to take it there. But for a property policy, where you're also buying business interruption coverage, as well as just covering your own property, your building's property. You know, there's obviously a chance that a terrorist act or something labeled that's actually certified as a terrorist act can take it down. And it's excluded unless you take the coverage. Business interruption, which we'll talk about a little bit in the cyber context, will also cover your lost profit and extra expenses. So if you have to go somewhere else to set up another office and rent equipment, computers, and pay a lease due to a terrorist attack, you do want the coverage. And it's relatively expensive, you know, on the order of hundreds or maybe low thousands of dollars. So we do think it's worth considering very seriously.
I want to turn toward employment practices liability insurance, which kind of will raise some of the issues that have been talked about, or at least touched upon earlier. Elliot, can you tell us a little bit about EPLI?
Sure. So as Baxter mentioned, the general liability policy is general, and it's really only intended to cover negligence claims causing bodily and property damage. It's not intended to cover claims for financial damage or some of the other types of issues that are excluded. So if pollution is excluded, you can look elsewhere. You can still insure pollution risk to go get a pollution policy. The same is true of employment practices and cyber, which we'll talk about here in a little bit. And incidentally, these two are sort of the hot topics in insurance right now in terms of claims activity. It's about as hot as it gets in insurance. But EPLI stands for Employment Practices Liability Insurance. And what it does is it covers the company for claims of wrongful employment practices. We'll talk a little bit about what that means by their employees. That's how it started and formed. There's an important extension that you want to consider, which is third-party EPLI, which also covers company and your employees against claims by third parties, or in the third party context, harassment and discrimination claims. So just generally, the employment practices policy covers claims of harassment, including sexual harassment, bullying, also discrimination claims, any protected class of individual, whether it be protected race, sexual orientation, sex, religious beliefs, any discrimination based on one of those protected classes would be the type of claim that you have coverage for. In the employment context, wrongful termination, breach of employment contract, and then workplace support, which is sort of an emerging issue. It's kind of expanding by the day. It used to cover things, strictly limited to things like misrepresentation, defamation, violations of rights of privacy alleged by your employees. It's been expanded and covered in many cases for things like negligent performance reviews, wrongful deprivation of career opportunity, so failure to hire, failure to promote. We've seen those claims as long as they're based on, covered type of discrimination.
Is there one size fits all type coverage here?
The carrier would have you believe that there's one size that fits you, which would be their standard form. But no, not really. And as Ted mentioned, any insurance policy can be negotiated, and there's a lot of add-ons that you can use to craft to really, tailor it to your needs, depending on the type of business you're in. You can also have, your attorneys get manuscript language for policies that carriers will agree to put in under certain conditions.
Got a question? Go ahead.
So would this policy dictate insurance to which attorney?
That's a great question.
Let me repeat it for the crowd. Would say it one more time.
So does this policy limit what attorneys you can go to when you go to Fox's?
Does the policy dictate which attorneys you go see?
So, in general, standard policy would provide the duty to defend. So the carrier is obligated to pay your defense costs up to the limit. Defense costs will reduce the limits. That's something to keep in mind when you're taking limits. In most cases, policy will say that the insured may choose defense counsel with prior written consent or authorization of the carrier. That's not always good enough for some of our clients. We work with Fox Gallup. They know our business better than anybody. We want to use them. They handle our employment. They do our employment law. We want them to handle claims in the event we get sued for wrongful termination. What you can do in that case is called manuscript policy. You want to do it up front at renewal or when you're placing the coverage to add an endorsement to allow the use of the law of your choice. Now, there may be in some instances a premium impact to doing that, but in most cases, the carriers will generally agree to it, and they may work out rates with the firm depending on the size and scope of the client. So, good question.
As with CGL policies, do we see exclusions come into play in these types of policies?
Yeah, I mean, there are several exclusions. Sort of an emerging issue as far as exclusions go is, in general, biometric or genetic information the company collects would be covered under the notion of right, right to privacy. Based on the emergence of multi-factor authentication, which will cover cyber, things like fingerprint authorization, other kind of biometric collection of data, being scrutinized more by the carriers, and there are some cases excluding that. You want to make sure that you include that information, or just remove the exclusion policy.
The other thing to keep in mind with that is potentially biometric is states are starting to pass privacy laws that create rights of action. Illinois is one of them. Privacy Act. And Illinois Supreme Court has ruled on that, where violation of the statute is in fact the injury, and they don't have to show alleged harm to the individual. Just simply violating the statute will allow.
Corner, question?
Yeah, real quickly, I get asked all the time by clients when we're discussing taking a case to trial or resolving a case, how is this going to affect my premiums? And I always give them a very generic answer, which is, well, the more money we spend either defending the case or the more money we lose, if we lose the case, is going to have an effect on your premiums. I know it's more complicated than that. Can Elliot and Baxter talk about that?
I mean, in general, if the insurance company is paying you more than you're paying them, that's gonna flip at some point. I mean, it's loss history is always a part of the equation that every insurance company takes into account when they're looking at not only an individual risk, but even at an entire class of business.
That's right. And when you're working with underwriters at renewal, and they're proposing an increase based on loss history, and they'll typically look back 5 years. It's kind of the standard. It's in that 5-year window, and they paid a fairly large claim. Some of the things that will benefit you, or at least reduce whatever the rate increase might be, are what have you done since the claim occurred to prevent future claims of that nature. So if it's an employee handbook issue, didn't have training going on, have you implemented those safeguards, that will usually satisfy the underwriter to some extent. They're basically at the mercy of the reinsurers who might be raising rates on them. So when it's a hard market, as it is right now, your individual loss history will play a role in whatever premium they may be quoting, but it's not the biggest factor by a long shot. There's also the opportunity to go market to other carriers, who may be more aggressive as far as pricing that coverage.
I've had the occasional client come to me with a potential claim, but their overriding concern is, what will this do to my premiums before they even make the claim? And I've invariably told them, well, you have to judge that, but remember why you purchased insurance. It's to cover you when bad things happen. So that should be your overriding issue before the claim is made. Do you need to make the claim? Then once it's made,
And
chips fall.
different insurance industry segments and different lines of coverage, the individual loss experience is going to be more impactful than in others. For example, in the marine world, the client's 5-year loss history is a paramount part of the underwriting process. Whereas on the employment practices liability, it's certainly always a part of the puzzle. But that will vary depending on what line of coverage it is sometimes.
We had a nice gender discrimination example. We're going to, in the interest of time, we're going to move past it. It's in your materials, you'll see it. I want to move to cyber liability policies. And Ryan, could you touch on that for us? And what does cyber liability entail?
Sure. So these policies are still very misunderstood. They're policies that protect the business in the event of a data breach, unauthorized disclosure, or access to information. And that could be both from external and internal threats, as well as information that's protected by statute in some way. And they also protect against the introduction of malicious code or other forms of cyber attacks, including or spreading malicious code. We've all got those emails where it says, hey, my email's been hacked. Don't respond to this. Well, technically, there could be claims arising from those emails if somebody's system goes down because of your failure in your security system. But these policies, they're not just for companies doing business on the internet or taking online payments. If you have systems that are in the cloud, if your employees are accessing things remotely, if your computers in your office are connected to the internet in some way, you have cyber risk. And that risk is generally going to manifest in one of 3 areas, either private privacy, security, or operations. And those aren't specifically coverage areas, which Ellie's going to talk about. But those are areas that you have to be concerned about when you're outlining and developing policies and proper response plans.
Brian, let me ask, does every business need cyber coverage these days?
And they should take a hard look at it. If they're using email, I'd suggest they look at it. If your system's entirely air gapped, which means it has absolutely no external connection and you have to interface with it, maybe there's an exception, probably not. And then as a general matter, these policies are going to cover both first and third party coverage. Kelly's going to cover in more detail. We're going to talk about the types of information that you need to worry about. Next slide.
This is a cyber liability exposure policy that was put together by the Chubb Group. Ryan, Elliot, really anybody, what is a particular interest here or noteworthy from your professional point of view?
So from my point of view, and I'm looking at this slide, these are all claims over the last decade for this particular provider, not necessarily incidents. So when people think of cyber risk, I think usually think of hacking. The landscape is much broader than that. 75% of these claims originate from hacking, human error, lost or stolen devices, and insider threats. You know, the rogue employee, all of which can be mitigated with proper training and security. Can't be eliminated, but you can.
Everyone hear me okay?
Yeah.
No, that's exactly right. I would just add too that if you look at hacking, we can almost equate it in today's landscape to those ransomware attacks. It's the primary driver of those hacking incidents. And then when we're talking about human error, which is 20%, we're talking in most cases about errors in terms of being duped or deceived by an email that you receive into parting with money or widgets, whatever you're making. So we call that social engineering fraud. It's kind of a term that's been given. So almost 50% of all claims are triggered by either a ransomware or a social engineering fraud incident, which we need to be careful about now because as the carriers have kind of caught on to that, we're seeing some restrictions being put in place around particularly ransomware today. I'll get into that in just a minute. But also social engineering fraud. What carriers started to do is they started to take a step back and look at what their policy said and then look at what actually happened. And they started so social engineering fraud is you receive an email and it looks legitimate, tells you to, pay a vendor, transfer funds, or do something, part with your property. You do it and then realize that it's fraudulent, bad actors have money, the money's gone.
And it's not that because you gave it to them.
That's right. So carriers began excluding that, or at least not including it in their policy under the notion that it's a voluntary party. Now you were deceived by the email, but you still press send. So
I should not have responded to that Nigerian friend.
There's not $40 million waiting for you. I'm very sorry.
Before we move from that, there's two other observations I want to point out. One, to put this slide in context for you with COVID. During 2020, the FBI had more than 791,000 complaints related to cybercrime, which with a total reported losses of $4.1 billion, just 1 year time. Right? The other thing is, you might think, why would they look at our systems, especially if you're a smaller company? Well, think about all the information you store. You probably have a treasure trove or identity theft just among your employees. About the types of sensitive information that a typical HR file would include about an employee, including financial information, because you probably have routing information for the bank for direct deposit. So that makes the smaller companies much harder.
You guys have mentioned ransomware. The next slide goes to that. What are we seeing of particular interest here?
So a couple of things. There's two observations. And Ellie, if you've got some to add on here. But First, even highly regulated industries, from a cybersecurity standpoint, like healthcare, which you can see on there, are still targeted. Because these are very sophisticated actors, in some cases, they're state sponsored. But bad, again, as I mentioned, smaller companies, bad actors understand that smaller support entities are easier targets as they function with available resources. A smaller company cannot bring to bear the cybersecurity protections that Microsoft is still one of the very much target. And I'm going to give you an example of that. Some years ago, you probably remember Target got hit. They had almost 40 million people their payment card data was released in the breach. That incident occurred because the hackers went to the HVAC provider who remotely monitored the stores, and they were able to jump systems and get into the administrator's accounts and access the data. That's what they do. They look for smaller entities that are advertising who they work for, that are known who they work for, and they try to get into larger information. So think about accountants who maybe they represent a lot of large companies that's on their website. That's a target.
Yeah, just to follow up on ransomware, just give you some idea of kind of what's going on. In 2015, the average ransomware attack resulted in a $23,000 settlement payout. In 2019, that number was only $28,000 on average. 2021, so far, we're seeing an average of $342,000 the average ransomware attack. So what that's doing is that's really driving price increases all across the market. Basically, insurers priced this thinking that they were going to get out of these things for $30,000, and it's not happening now.
Does that mean that there are more claims against large companies, or is that including individuals like anybody in this room?
It's really anybody in this room. We read the headlines of the larger pipeline attacks where there's millions and millions of dollars being requested. But the Department of Justice has a list essentially of two types of bad actors. There's the bad okay actors who you have to pay. These are like the Russian hackers who are hackers hired. They're really in the business, hacking your system, lock your data, demand that you pay them what they want. They're generally honest criminals because if you pay them, they will unencrypt the data, they'll give it back to you. Another thing that they're starting to do too is to the extent you have really, really good backups, and you can restore your system and think, well, I don't need to pay them because we have good backup. We might lose a day or 2 days of working data, but we can, put our network back together. Now they're threatening to just make the information that they hold public. So they'll put it out on the internet. It's confidential information. So that'll trigger another type of cyber. And then there are the bad actors that are bad actors. There's one terrorism, which the DOJ says cannot pay, shouldn't pay, your policy won't pay.
Kelly, can you touch on policy coverage briefly? What is usually entailed?
Sure. So as Ryan mentioned, there's third party, which basically think any liability. Somebody sued me based on my handling or mishandling of electronic information or data. Privacy and security liability is really the meat and potatoes of the cyber policy. It's basically covers claims for unauthorized access to data, failure to notify individuals or companies or business partners of breach when it's occurred, failure to protect and destroy confidential information properly, failure to prevent a security breach that allows typically a bad actor to launch another attack. So if you're involved in the transmission of malicious code, even without your knowledge, to hack in the injure servers to launch a denial of service attack or something like that, you can still be liable. You'll be named in that suit regardless as an indispensable party. You may not have all the liability, but you definitely want to be defense counsel for them. Media liability, real quick, it's just libel and slander type claims in electronic content. So you have a website, something out there that infringes copyright, or you allow people to post comments to your website, maybe as a customer portal or something like that. Want to be protected there. Regulatory proceedings. This covers fines, costs associated with agencies bringing action against you for a breach, for your failure to handle the breach, or mishandling the breach. And as Ryan alluded to, so there's a lot of consumer privacy laws that are being enacted right now. California enacted theirs about 5 years ago. They spent $50 million setting up a task force to enforce it. Okay, so the government doesn't spend that kind of money without expecting to get it back somehow. So we expect regulatory fines and penalties to increase as time goes on.
Real quickly on that, I just want to point out, just because we're talking about California laws, Illinois laws, keep in mind, these laws are designed to protect the residents of those states. So if you're a Missouri employer with Illinois resident as employees, the biometric protection law applies to them. They can file a suit over there and bring it into. Same with California. They have a lot of jurisdictional levers they put in to bring you into their coverage.
There are additional aspects of coverage that are in the materials. Elliot, can you touch on policy exclusions, which again are, I would think, critically important?
Yeah, so some exclusions and pitfalls that we want to be aware of that are kind of emerging daily as carriers are losing money really on this line and are trying to stem some of those losses. We're seeing the introduction of cyber currency exclusions. This is a huge problem in the event of a ransomware attack. The request is going to be that you pay in Bitcoin or something like that. So have your attorney or have your broker review the policy to make sure that cryptocurrency is covered currency under the policy. In the tax world, crypto is a security. In the insurance world, it needs to be a currency that's covered. Coverage, territory limits. Also, you want to have worldwide coverage territory. You might be turning your data over to a vendor that hosts it. It's offshore. U.S. territory limitations aren't going to cover that. There's one carrier that actually offers basically it's worded that territory includes anywhere in the universe. Okay, we thought this was a little bit tongue-in-cheek initially, but their reasoning was that there are satellites in space that data bounces off of and stores data, so they want to say, look, we're the broadest, we have it up in space as well. Tech, if you're in the business of IT and computing, you need a separate professional lines policy that will also include these cyber coverages. So be aware of that. Callback requirement. This was something that was introduced after the social engineering fraud losses that we saw a few years ago, which can be a huge problem. It basically requires that before you press send, in response to that accepted email on the money that goes out, that you actually call the person you received the email from, telling you to pay the vendor. So that kind of negates the need for coverage. If you recall that person, spoof email there and send that. So you want to get those.
There are important issues here too with respect to how do you apply for this coverage and why does coverage sometimes get denied. In the interest of time, we kind of have to skate through that, but there's good stuff in the materials. And I encourage you to call any of the people on this panel.
I just have one more important thing.
Quickly, yes.
So work from home is a huge issue right now. So in most policies, it defines covered computer system as equipment and computer systems that you own by the company or they're controlled by the company. You have employees working from home on their own device, their own laptop, they're getting in. You have to be very careful about that. One is called BYOD, bring your own device. So that's just something that's kind of
Quickly, one point from each of you. Emerging trends. If you put down your wizard hat, you're looking 5 years ahead. What's out there? Baxter?
First. I think it's the continuing evolution of specialty coverages like cyber to fill these niches that it's difficult to predict. I mean, if a client had asked me about pandemic coverage 3 years ago, I would have said, what's that? And now I'm principally a Marine guy, so that's probably part of it, but still there's I think we're going to continue to see, and we have continued to see, very specific niche products for certain things. Parametric insurance is another example, which is basically buying insurance covered on weather. Cyber liability, I think we will continue to see these pockets of cover opportunities that develop in response to people thinking of greater and more inventive ways to screw it.
Elliot?
I would agree with that. In the cyberspace, expect to see multi-factor authentication requirements. There's an annual report published by Lloyd's in London. They have 80 syndicates that underwrite cyber. All 80 in the past year were basically at combined loss ratios of over 1. So for every dollar they were taking in premium, they were paying out over $1 in losses. Lloyd's does not lose money. They're not in the business to lose money. So just about every syndicate that writes cyber now requires multi-factor authentication. To give you an idea, it averages about $3 to $5 per employee per month. Implement multi-factor, so 100 employees, it's $5, $6,000 a year. It's not necessarily cost prohibitive, it's something to look into. And for those carriers that don't require it, it can really lower the premium increase you have it. I think the other thing that's going to come out here in a few months, next few years, is also they're going to start looking hard at how you protect your backups. Because some of these hacks have the ability to infiltrate your backups. And if you don't even have a way to restore your network from your backups, that can make a problem.
Well, I would like you to join me in thanking this excellent panel today. And thank you for attending today. Those of you online and here in person, very much appreciated. Fill out the evaluation reports. And yes, ma'am.
I have a question from the chat it's
I'm
regarding OSHA. So this is for Sarah or Stas, if you'd like to come to a microphone while I read this question.
You guys are off the hook.
This question is, and I'm quoting the person sending the question. I understand the emergency OSHA mandate is questionable, but I still didn't hear any thoughts about the potential to public entities in Missouri who are not under OSHA jurisdiction.
I'll give it a shot. So as far as what we think the mandate is going to apply to, it's private employers with 100 or more employees. I don't know if they're going to include public entities in that, or if they're going to have different size requirements. We just don't know. I think if you want to be extra careful, I think take the same proactive steps as if you would if you assume it's going to apply to you that we talked about earlier, and kind of get a feel for how many of your employees are vaccinated, start planning out how you're going to implement potential testing requirements. But we don't know. We don't have those details.
Thank you again, everybody. Fill out your evaluation forms. They really help us. And thank you, and be careful out there.